Welcome to the Doctors on Social Media podcast. Welcome to SoMeDocs. I'm the founder of this venture, Dr. Donna Corriel, a curious internist turned digital entrepreneur. I run this beautiful community and encourage you all to subscribe, engage, and join us at doctorsonsocialmedia.com. The following is a conversation we had with a professional in healthcare, now available to both watch in video or listen to through audio podcast. We hope it entertains, inspires, and ignites conversation. Don't forget to check out our other unique resources on our website, and of course, share this with your friends. Hi, everybody. So I'm Donna Corriel, the internist that founded SoMeDocs, and we are recording another episode of SoMeDocs Conversations. It's a very timely episode, and so I'm going to be working on this post-editing process right away because I am joined by lawyer Kyle Claussen. And you know what? I didn't even ask you how to pronounce your name. Why don't you introduce yourself?
You nailed it, Kyle Claussen. Yep. I'm an attorney, CEO of Resolve, and we spend our days helping and advocating physicians with their contracts. And so we're happy to be here and talk about all things non-competes.
I love that. All right. So non-competes, let's dive right in. It's certainly a topic that's been the bane of my existence, not because I personally needed to leave any place of employment and was resisted. Could you maybe start by explaining to the audience, to those listening, what that word means, what that term means?
Yeah, so a non-compete or restrictive covenant is a paragraph or section in your employment contract that prevents you from doing something, usually post-termination. So you're not allowed to practice medicine, right, within a certain area, geographic area, for a certain time period. And with the shift over the last 10 years to physicians being employed by health systems, academic centers, private equity, the data says that 45% or more of physicians have non-competes. From our seat, it's like 95% plus have non-competes, and so they're really damaging. They're terrible for any renegotiation. It removes leverage, and so that's part of what the FTC made a ruling on, and that's what we're here to talk about.
Okay, wonderful. Do you know how many years this restrictive covenant issue has been in place?
Well, I mean, they've been around for a long time. And so they historically are there for, right, business protection purposes, where if we have intellectual property or patient lists, right, there's valid reasons why you want non-competes in certain industries, or there at least was historically. The question is whether or not those should have ever applied, right, to healthcare or to physicians. And I think there's a lot of good arguments, on why they shouldn't. Usually, though, if you're asking a timing question as far as how long do they apply post-termination, usually between 1 and 3 years. And there are some states that have come out even prior to this ruling that have said you can't go beyond a 2-year time frame. But for most people, whether it's a year or 2 years, you can't go without work for a year. So that part is less important. It's usually the geographic area that becomes a problem.
Okay, yeah, that's important. Just the fact that there's different factors in this, and it's both the time factor and it's the geographical factor. Um,
Correct.
and just to put it in perspective to the people listening, from a doctor's perspective, it sort of limits us when we stop working for a certain entity. And from my understanding, even when they fire you, it's not even when you leave them, it's even when they fire you that you cannot set up shop and maybe just form your own private practice within a certain geographical region for a certain amount of time. So let's say hospital system, A fired me. I would not be able to build a private practice within like whatever it is, a 5-mile radius or whatever it is that they got me to sign in my contract. Am I saying that correctly?
Yeah, that's exactly right. So they're generally drafted to say, regardless of how the contract ends, you can't work at all, whether you're forming your own practice or going to a competitor within 5 miles, for example. It could be 10, 20, it could be 100 miles if you're in a rural area, right? And the problem with that is, there's a lot of M&A action that happens, right? If you're in a private practice that gets sold to a health system, should you still have a non-compete, right? That's a bad outcome. If they terminate you for no reason, they just let you go, they change their mind. Should you be prevented from working in the area, that's also a bad outcome. And so there's a lot of ways to try to solve for those solutions. Obviously, if this ban, is in place, that's great. You don't have to worry about it anymore. But until that point in time comes, all of these things are really important to try to monitor and to fix in your contract.
Okay, good to know. All right, I am going to refer to, I mean, there's several sources that or resources that you've shared that got my attention. And so I'm going to kind of go into it in order to ask questions that I have. So there was a little cheat sheet that with your permission, will share underneath the show notes here. And of course, it has your company logo, so that will
Yeah,
give
great.
attribute to resolve. Yeah. And can we talk about some of the specifics of this new ruling? Can you tell us, first of all, about the ruling?
Yeah, so the ruling came out, yesterday, and it's all, promulgated on the FTC's ability to create rules to prevent unfair competition, right? And so Congress gave them that authority, and they've now utilized it to say if you have a non-compete or if you try to enforce a non-compete, we deem that to be unfair competition. Um, we can talk in a second about the lawsuits that have been filed and the potential to, say that they don't have that authority and the stays that'll likely happen while they figure this out. But that's the broad definition, right? Is that the FTC is saying that no non-competes are no longer effective, even retroactively, right, backwards in time. And so they do have carve-outs and exceptions, in there for profit versus nonprofit, which they don't have authority over. There's exceptions for senior executives, and we can talk about the definition on that as well. But it's a pretty broad, right? It's a pretty broad ruling and touching a lot of areas of the industry, not only healthcare, but I mean, it's for everything at this point.
Okay, good to know. So, from a general perspective, like in a broad perspective, what
Mhm.
does that mean for your average doctor who is practicing in a system that has signed a contract with a non-compete in it?
Yeah. So if you're a normal physician, right, today that's employed in a health system, your first question is going to be one, when does this kick in? And so by the rule itself, it's 120 days from the time it hits the Federal Register, which is going to be likely, uh, sometime soon, which means late August, early September is when this would kick in, right? Assuming that there's not a lawsuit or an injunction that stops it or delays that. So as of today, right, your non-compete is still enforceable. It's not going to be unenforceable until this is effective. So be careful on that. But the second thing is you need to decide if you're in a nonprofit institution versus a for-profit institution, because at a high level, the FTC cannot regulate nonprofit entities. Now, they go into discussions on if you're a nonprofit, but you act like a for-profit, right? And you've ceded some authority and some control to for-profit entities, that we're going to still apply this to you. But that's kind of a maybe, right? It's not a clear definition of what that looks like. It's very facts and circumstances type of analysis that'll have to happen. So your step one would be am I with a for-profit? If I am, this applies to me unless, right, I'm considered a senior executive. And if I'm a senior executive, then there's, potentially a carve out there as well. So that's step one. Wait the 120 days or longer, and then two, make the delineation between what type of entity you're working for.
So if you are an executive, if you're in an executive role or position, are you saying that the non-competes could still apply to you?
Yes. So if you are considered a senior executive, they're saying that this ban does not apply to that level, right? And senior executives are people that make more than $151,164 a year, which is most physicians, right, are going to be across that threshold. And, right, it's a two-prong test, and you're in a policy-making position. And so the question is if you're a physician in a for-profit entity, are your duties, right, in your scope such that you are in a policy-making decision-making position for that entire organization, not just for a department or a small area. The FTC has a specific discussion about this for physicians. It says that if you're in a private practice, right, or an independent group where you're a partner, kind of a president type level position where you're able to make decisions, this would apply, right? So you would be a senior executive in that situation. If you are just a normal, right, physician in a health system that likely doesn't control everything, budgeting, finance, all that stuff, it will not apply to you. So they've given some clarity on that, and I think that that's really helpful.
But could this be to some degree a loophole that's created so that any contracts that are being formed from now on, right, by large health systems that know the new ruling, they can sort of manipulate the verbiage of their contracts to insinuate or indicate that the physicians that they bring on have some sort of role that fits into this type of thing. We'll be right back. Check out a snippet of this series from SoMeDocs. Dr. Vonnegut converses with Sam Shem, who wrote The House of God. We've got 2 whole seasons of talks.
I was explaining about what we had for behavioral health care. We had the art room. We had an art therapist. We had all those wonderful things. And he cut me off and he said, all well and good, Dr. Vonnegut, but if the dollars work, nothing else matters. And
dollars work, nothing else matters, whether they'll take you under their wonderful wing,
right,
or not, with the clause.
Right.
Yeah.
It's also interesting that I had no choice.
Find it at doctorsonsocialmedia.com/series. Now back to the show. But could this be, to some degree, a loophole that's created so that any contracts that are being formed from now on, right, by large health systems that know the new ruling, they can sort of manipulate the verbiage of their contracts to insinuate or indicate that the physicians that they bring on have some sort of role that fits into this type of thing?
Potentially, yes. I mean, I think if part of your duties and responsibilities section of your contract says that you have, some role in a committee that has policymaking authority, they may lean on that, right, in the future to say you are considered a senior executive and therefore we can have the non-compete.
All right, so this goes out as a warning to all the doctors that are looking to get hired by new positions and in new jobs. Make sure that your lawyer is looking for that verbiage so that they don't trap you in that loophole.
Right.
So you're saying, if I'm understanding correctly, that nonprofit hospital systems do not actually have to abide by this ruling?
Correct. So the FTC generally doesn't have control over nonprofit entities, right? Their rulings don't apply. So it's not just this one, it's all of them. But in their rule and in their decision, they talk specifically about healthcare a lot. There's, over 100 references to physicians. And so this is well thought out on their end. They know it's going to be applicable to for-profit systems. And they also they say specifically that some portion of the 58% of hospitals that are nonprofit are going to be subject to this rule. The problem is they don't tell us which ones out of the 58%, right, are, which is why it's a very, fact and circumstances analysis. It's going to have to happen at some point.
This might have some legal sort of history to it, but why are nonprofits not, why are they treated? I mean, they're nonprofits, so there's different factors, but why are they treated differently? What's the thought process behind that?
Well, the thought process is that if you're not in business to create profits, right, that we don't have to regulate you as much, right? You can think, hospitals, obviously, academic centers, churches, right, things like that. But the problem is that, underneath the IRS definitions, people have abused that historically, right? They've created nonprofits and then really had for-profit arms. And so that's why I think the FTC is saying it doesn't matter what you filed on your IRS form. We're going to look at what you're doing day in and day out to decide if this should apply to you. And with healthcare being, 20% almost of our GDP, it's hard to imagine that that's all nonprofit work that's going on.
Okay, good. I wanted to hear that because I do think there's so much sort of manipulation out there about this whole term nonprofit. And I've seen it happen in real life where people will just call something a nonprofit when there's clearly a profitable angle to it. Okay. All right. What other factors are important for a physician audience and a legal audience to kind of hear from you in regards to this new ruling?
Well, I think as a starting point, I would say that if you're negotiating a contract now, right, you're either entering into a new one or you're renegotiating your current position. You should utilize this, right? It's not a perfect rule. There's exceptions, there's loopholes that may or may not apply to nonprofits, but it does give some tone, right, to the industry. It does show that this is maybe the way things are heading. And so if you're now going to be signing a contract with a non-compete, it'd be a great time to just take it out, right, or modify it to a point where it doesn't apply to you anyway, right, if the geographic area can be so small. I also think if there's refusal to move on that by, your employer, all of these definitional things now become really important, because what you don't want to have is, yeah, we'll take the non-compete out or we'll leave it in, but now you're a senior executive like we talked about before. So I think you just need to be really careful, right, while this plays out in the system, which may take a while. I mean, I'd love to say that it's going to be in place in September, but it's probably going to be a year or two before this all gets sorted out.
And speaking of timeline, is there a possibility that there's going to be an appeal?
Yeah, I mean, I think that's what's happening right now is, the U.S. Chamber has filed, Ryan Corporation, there's a few that have already come in. The American Hospital Association, right, is not thrilled about this for a lot of reasons. They were opposed to it. And so certainly the court process, I mean, depending on the ruling, likely will get appealed anyway. And so we are in for a slow grind on this one, probably.
And in terms of before this ruling took place, was the non-compete actually enforceable?
In most states, if it was reasonable, it was enforceable. So there's a handful of states like California that have just banned them entirely for physicians, right? Which is great. And other states could do that too, and we wouldn't need the FTC if everybody came together and said we don't want this to apply to healthcare. But if they were reasonable on time, scope, right, and geographic area, they could enforce them. And I think there's a misunderstanding about that, especially in the physician world and physician communities. A lot of people say, "Oh, they're not enforceable," right? Or I've seen people leave and nothing happened. I think you got to be really careful with that, and you're taking a lot of risk if that's your position. So we encourage everybody, drive down the terms on those to levels that you're comfortable with if they won't remove it entirely, and give yourself options, because you never know what your employer's going to do.
Okay, great to know, because you're right. This is something that just myself being in so many physician circles that are both advocacy related and side venture related, this comes up a lot where the doctors are constantly sort of arguing with one another whether this is enforceable or isn't. So it does sound like it's something to take seriously and not something to just kind of wave away when it's written into your contract.
Yeah, and I think the problem too is that because it's so fact specific, I mean, specialties are going to matter, right? Cities are going to matter on whether they're enforceable. So even within a state that allows them to be there, it may be different for radiology than it is for pediatrics. And so in these communities, if somebody says, "Oh, mine wasn't enforced," that doesn't mean that yours won't be, right? And so again, just caution is what I would advise anyone that's looking at these.
Yeah, that sounds fair. And what about people that are currently in litigation um,
Mhm.
for these issues?
Unfortunately, that's an exception. So if there's ongoing litigation on a non-compete, the FTC has said we're going to allow that to happen and to continue to move forward. And so if you have a non-compete, you're in litigation on it and you lose and it has to be enforced, this new rule is not going to help you. They're going to leave that in place.
So, can you talk a little bit about this term Stark violation and explain to us a bit about Stark laws and how they're different than non-competes?
Yeah, so the Stark law is there to prevent referrals, right, and improper referrals from physicians to other entities. There's exceptions out there for employed physicians, but interestingly, in the commentary of the rule, it talks about whether or not employers have utilized non-competes as almost a way to promote referrals within a system because you don't have another option, you can't leave, and so it's kind of a skirting the issue type of thing, and I don't think that was ever. I didn't anticipate that being there, I guess, and so I think that's an interesting take by the FTC to bring that in. Certainly, we all know, right? We want to be compliant with Stark. We want to make sure that we're being paid fair market value and not more than that for referrals and things of that nature. Really important in the health law world. But I do think you're going to see, if this rule is upheld, right, maybe some more scrutiny on those things as far as what's being paid and how those referrals are happening. If there's not a kind of a get around that Stark rule with a non-compete.
Yeah, that's going to be really interesting to see play out. I think it's also really interesting to see this play out as so many of us are beginning to kind of mobilize and activate behind the scenes where it comes to like our advocacy resources like SoMeDocs, building a health media site that has a magazine and series that speaks about private practice and the benefits of physicians breaking free from systems and sort of building their own entrepreneurial ventures. I imagine that Stark laws are going to be, I mean, they apply there as well. Do you have anything to say in regards to that?
Yeah, I mean, it's all about, the designated health services and right, what's being passed back and forth. And if physicians are acting right the way that most of them do, which is appropriately, it's not an issue, right? It's only in the event where you feel like a health system is paying compensation or doing something for the referrals, the ancillary fees, the surgery fees, the cath lab, all that stuff that happens, behind the scenes. So I think the move to private practice, right? And if this happens, you assume a lot more will do that. It would be a great thing for competition.
Awesome. I am all for competition. And again, I've been pretty vocal online just about the state of affairs of medicine and doctors practicing within it, and the fact that we do feel like we are essentially owned and controlled by these large systems. Do you have in general anything to say to both me and what I'm sure will be hundreds, if not thousands, of doctors that are listening to this and feeling the same?
Yeah, I think you should feel empowered, right? I mean, I know that we've kind of maybe walked ourselves into this situation where a lot of you are now employed and there's non-competes in place, but the supply and demand is a real thing, right? There's not enough of you, right? The entire market, the entire country needs healthcare. And so I do think from where we sit, when physicians push on issues, they often get what they need, right? If they're really willing to push. But if you're not, if you don't have leverage, if you're not willing to take some of that risk or go out into private practice or sit out your non-compete, whatever it is, that's where we see the systems kind of push back and roll over some people. So I think empower yourself with education, right? The communities are great. Any type of tooling, right, that gets you that information is really, really important.
What I've personally noticed is a roadblock for us, and I'd love to get your opinion on this just from a legal perspective, is that um, there's so many different specialties of physicians that almost like differentiates one from the other, and it prevents us from cohesively coming together with the sort of like same mission and goals. So I always kind of compare us to nursing, right? Where, I mean, you could be a nurse in different departments, but at the end of the day, you work fairly the same, right? You work shifts. You're getting paid more or less the same. And
Right.
it's so not like that in the physician world. What are your thoughts on that?
Yeah, I mean, the category of physician as an occupation is doesn't feel accurate to me, right? Because an ophthalmologist is nothing like a radiologist and is nothing like a pediatrician. And so it feels like you've gone through training to get to a spot, but really your subspecialty training is the occupation title for me. Your terms of employment are very different, right? Hospitalists work shifts and others don't. Radiologists have a ton of vacation and others don't, right? So I just think it's hard to get people together and to advocate for things when they're treated differently, for a lot of reasons. And some of those are the stark reasons we talked about. But when we see surgeons come in, right? I mean, all the hospitals want orthopedic surgeons because they drive a ton of ancillary revenue. Whereas a pediatrician, they need that, right? It's a great feeder. It's the top of the funnel. But from a revenue standpoint, they don't generate as much. And so I think it's hard to get everybody in the same pool to advocate together. And that's what we see anyway.
And what I'm feeling frustration at from a, physician perspective is that there are organizations that have been created many years ago that represent individual specialties, but I don't personally feel like most of the time they do represent our concerns, and that's where my frustration comes in. And I'm also wondering where you come in on that is just again that like as an internist, I don't necessarily know that there's an organization that accurately represents my growth. We'll be right back. At SomiDocs, we're building you incredible conferences that you can soak up from the comfort of your own home, even in your PJs. Save money, save time, and save on stress because they're all virtual. They're each curated with today's top experts in fields like private practice, writing, obesity medicine, gut health, cancer, dermatology, neurodiversity, non-clinical work, and others coming on social media, marketing, side ventures, health advocacy, and more. Back to the episode. Like as an internist, I don't necessarily know that there's
an organization that accurately represents my growth.
Just chiming in here post-editing, folks, that should have said accurately represents my gripe. Zoom was doing its thing and sort of cut out some of my words, so I just wanted to hop in here and let you know what I said.
Yeah. So the AMA, the national societies, right? I mean, I think there's some frustration historically with how they have advocated maybe for their specialties. We have clients that, come to us from areas that have unions for physicians. And I think it's the same frustration, is that the union in theory was a great idea, but now it represents all of us. And so really it represents none of us. And so they feel like their contracts aren't applicable either. So we take the position, and what we do all day, every day, right, is we advocate for individuals because everybody's different. Some people want 4-day work weeks. Some people want more vacation. Some people want a max compensation out. And I just think it's difficult to get everybody on the same bus. And so I think you just got to do what's best for you.
All right, that's great. And I love that. And that, speaks to the power of hiring an attorney individually that sort of can focus on your own specifics. Yeah, as opposed to what I and some other leaders in the field are trying to do, which is bring us together for a certain cause so that we can kind of make noise enough to bring attention to matters. Yeah, I think we need both, right?
You have to have both. I think the noise is great because the noise maybe gets the FTC to do some stuff like this, but then it's also, for you individually, right? Even once the noise is created, you're going to have different needs than somebody next door to you. And so you have to solve for both of those things at the same time. And I think you can, if we all get there together.
I love that. All right. So with that, I think we've covered this new FTC ruling. Is there anything you can think of that is pertinent to the FTC ruling that we can still sort of add in here?
How much do you talk about side gigs?
A lot. We
Okay,
have a group that's called Side Ventures.
Yeah, so maybe we want to talk about this does not apply to that. They can still prevent you from doing side gigs in a contract.
Oh, yes, please. Let's talk about that.
Okay, so one of the other carve-outs or questions on applicability for the FTC ruling is whether or not it also applies while I'm working for an employer, right? So can they prevent me from doing side gigs? Can I go moonlight, consult, be an expert witness, all the stuff that you may want to do outside of the contract? The ruling does not touch that. It is only focused on post-termination restrictions. It's not focused on restrictions while you're employed. So I do think, if you have that interest, which I know a lot of physicians do now, just understand that this new ruling doesn't help you on that. You're going to have to change that in your contract and negotiate those things that you need.
Okay, this is huge because, again, not only do I lead a large community of doctors that are looking to pursue side ventures, but they also are already engaged in side ventures. So I do want to kind of talk about that for a few minutes, but I am going to ask for you to come back and we will do a whole different episodes on side ventures and maybe even like live stream it so that docs like in real time can ask us questions.
Yeah, that'd be great. Be great.
Yeah. So okay, so this is not necessarily applicable to the side ventures, which is a problem for a lot of physicians. But, I guess it depends on the specifics of the side venture because really, when they write things into their contracts, the health systems, they just want to make sure for the most part, and you can correct me if I'm wrong, but they just want to make sure for the most part that we're not working as doctors anywhere else. Am I right? Or do they sneak in other language?
Some are like that, but some are everything, right? They don't want you to do anything that one takes away time. They don't want you to work for a competitor. They don't want you to utilize their resources or data, right, for intellectual property developments or other things, unless you share ownership or give them ownership on that. Most are drafted so broadly, though, that they don't apply just to medicine. They apply to consulting, social media things, right, expert witness testimony, all the categories you could think about. And so I do think you need to be careful, regardless of the FTC component, just if you're looking at your contract generally, on what you want to do and what the language allows for. Most you have to get consent on, right? Which is a tough spot to be in because they can always say no. And now you're stuck.
Holy moly is the only thing I can think of to answer. And I wanted to answer in a way that would make me feel bad because I'm hoping that, people will comfortably watch this. I was going to use some of my French. But wow, this is really important. So I am going to actually invite you back because I do want to do an entire different episode on side ventures. I think it's huge. And I think
Okay.
that so many doctors out there that are going to have questions for you on side ventures. And again, I think that this is where physicians need to team up with the legal world because they're sort of out-muscled when these big hospital system hire these really powerful legal teams to draft up contracts that really bind doctors in a way that they're not happy with. So I think we're going to have to, yeah. So if you'd be willing to come back, I do invite you to come back and let's do a side venture episode.
I'd be happy to. It'd be my pleasure.
Awesome. Awesome. Thank you so much. Any ask before we close this out?
No, I think this was great. I appreciate you putting it out there.
Absolutely. And I'm going to include in the show notes, you know, Kyle's contact so that if anybody has anything they want to contact him on that they can. And again, thank you so much for hopping on.
Appreciate it.